Good afternoon, and just to inform people that this session is being recorded. If you have any questions, please type them into the Q&A function at the top of the screen, and we will answer them as we move along. If we don't get to answer one of the questions, a transcript will be taken and the answers are going to be circulated afterwards. So welcome this afternoon. This is a presentation on the Assisted Decision Making Capacity Act with a specific focus on discharge from wardship. And Anya Flynn is also joining us after the discharge from wardship presentation to take you through what the role it will be for a co-decision maker and a decision-making representative in terms of their responsibility with the responsibilities to the decision support service. I'm also joined here today by Mary Claire Butler, the Deputy General Solicitor for Minors and Wards of Court. So the Assisted Decision Making Capacity Act commenced on the 26th of April 2023, and the Wards of Court Office continued accepting applications until the 25th of April 2023, close of business on that day. All wards of court are required under the legislation to be discharged by the 26th of April 2026. When they are discharged, there is 3 tiers of support, one of which will be recommended if the person does require decision support assistance, or else the ward of court or the relevant person may be discharged on a finding of having full capacity, in which case they're remitted to the management of their own affairs, absolutely. Now, transitional arrangements were introduced under the Assisted Decision Making Capacity Amendment Act of 2022, and these transitional arrangements provided that all applications received to the date of commencement of the Act can proceed in the wardship list through to declaration stage, with an option then for the solicitor to withdraw the wardship application and seek a declaration under Section 55 of the Assisted Decision Making Act. However, this has not occurred in any single application that we had received to date, and the court is still declaring adult wards of court. In fact, for the year of 2023, we have declared 208 adult wards of court, despite commencement of the Assisted Decision Making Act. So, as I've mentioned, there are 3 tiers of support. And assisted decision making has replaced substituted decision making in Ireland. Substituted decision making was what was available in Ireland since 1871 under the Wardship Court. As I've mentioned, all wards of court will be discharged. Following a functional capacity assessment that recommends a particular tier of support, or where somebody's found to have full capacity, they will be discharged quickly and with no tier of support required. So the lowest tier is a decision-making assistant, and this might be where somebody's found to have capacity, possibly in 1 or 2 of the areas, but they might require assistance, for example, dealing with property and financial affairs. And this could be assistance in filling out forms, or perhaps engaging with a teller in a bank. It's a very informal process and form of assistance. This next tier of support is where a person would be discharged with a recommendation that a co-decision maker support them when they're making decisions. The co-decision maker makes decisions jointly with the relevant person, but at all times giving way to the will and preference of the relevant person. However, the only exception to this would be if there is a risk of harm to the relevant person or to another person arising out of the decision being taken. The highest tier of support is where a person is discharged with a decision-making representative. And at all times, consideration must be given when decisions are being made to the guiding principles set out in Section 8 of the Assisted Decision Making Capacity Act. Now, being discharged with a recommendation of a decision-making representative, it would be the closest thing to where a ward has been discharged. The decision-making representative is very similar in terms of a committee that is in place at this time. The decisions are taken on behalf of the relevant person, but also recognising what their past will and preference may have been. And this could be something that was recorded or by engaging with people who knew the person prior to them losing capacity. The functional capacity assessment will be carried out by one of the court's medical visitors. The Wards of Court Office will arrange for this to be carried out. We will contact one of our court's medical visitors and ask them to make contact with the committee or the relevant person, or perhaps the service provider. The assessment will be carried out at a time and place that is suitable to the Ward of Court, to the committee, or to the service provider. The functional capacity assessment will look at the relevant person's capacity in the areas of healthcare, welfare, and that includes their activities of daily living, and then finally property and finance. And the assessment will take into account the person's ability to understand the information that is available to them and relevant to making the particular decision. Their ability to retain that information long enough in order to make the decision, and also their ability to weigh up that information as part of the process in making the decision. And that can be looking at the pros and cons in assessing the decision, but also the consequences that will arise out of making that decision. Their ability then to finally communicate the decision, and communication is not just verbal communication. It can be by means of writing, using sign language, use of assistive technology that's available to the person, or to communicate by means of a third party. So that might be somebody who's very familiar with the person, or it may be that English isn't the person's first language and they require a translator. Now, the court's medical visitor will make a recommendation in the functional capacity assessment as to the tier of support they believe the relevant person will require on discharge. So the discharge application itself. So who can bring this application? Well, the committee for the Ward of Court themselves, or on consent of the court. And this was included as part of the Amendment Act of 22 that I mentioned. A relative or a friend, somebody who's in a position of trust with the relevant person, who has a pre-existing relationship, interest, or even professional expertise. So this could be another relative who isn't the committee. It could be somebody working with a service provider or an advocate working with the Ward of Court. Now, the application for consent is made to the ward through the Wards of Court office in the Wardship list. It's made on affidavit, and the relevant person or the Ward of Court and their committee need to be put on notice of the application. The court will then make a decision whether to grant the application, and if they grant it, a court order will issue authorising this other person to bring the discharge application. So the first step in the discharge application process is to lodge a notice of motion in the office. Now, the notice of motion is it's open in terms of a relief. You're looking for the discharge of a relevant person or a Ward of Court under Section 55 of the Assisted Decision Making Act. Please ensure that the Registrar of Wards of Court is addressed in the body of the motion, in addition to the relevant person and the committee where somebody else, another person, is bringing the application. You need to be clear about who is moving the application. So the applicant needs to be named in the body of the notice of motion. So that will either be the committee, the Ward of Court, or the person who's been authorised by a court order to bring the application. When you're lodging the notice of motion, please lodge an original and 2 copies. One copy will be, the original will be retained in the office, and both copies will be returned to the solicitor lodging them, one for service and one for retention for their records. The notice of motion itself will only issue when all other documents have been lodged in the office, have been checked, and are deemed to be in order. So what are those other documents? Well, as I've mentioned, the Wards of Court Office will arrange the functional capacity assessment. We'll receive the report, we will send it on to the relevant person and to the committee or the applicant, and that will be through the solicitor. The Wards of Court Office will prepare a document known as a Schedule of Assets and Income. Now, that's what is known to the office. So we will set out what income the person is receiving, what property they own, what the level of funds are that are lodged in court on their behalf. We would also note any bank accounts that remain outside of court and that are open, or there might be a credit union account. If they have a car, if they have a camper van, maybe for holidays. But if a person has a holiday home, say up in County Donegal, and the office has never been informed about the holiday home, we can't include that on the Schedule of Assets and Income because it's not known to the office. The Wards of Court Office will also provide copies of any relevant court orders and reports, medical reports on file to the solicitor for the applicant. Now, this will include the declaration order, any relevant orders dealing with medical treatment, or any orders dealing with protection of liberty, safeguarding orders. These will be provided to the solicitor to be included as exhibits to the grounding affidavit. It is also open to the applicant or to the Ward of Court to obtain their own functional capacity assessment and submit that for consideration by the court. Now, this may arise where somebody disagrees with the recommendation of the court's medical visitor, or they might just want their own independent assessment to be carried out. Some of the applications may require a proposal on the future management of the funds that are lodged in court. Now, what I would say is either make contact with the individual case officer assigned to the Ward of Court and have a discussion around this. Where this is going to be relevant is for anyone who has received a very large personal injury, medical negligence settlement under a High Court proceedings. So some of these can be as high as 15, 20 million euros, and they're provided at that level to ensure that there's sufficient funds for the future care of the relevant person for the remainder of their life. And the court will want to be satisfied that arrangements are going to be put in place to ensure that those funds are managed. Where there's a recommendation that the person be discharged with the assistance of a decision-making representative, there is a statement to be signed and by the decision-making representative, and this will be witnessed then by somebody other than a party to the proceedings. The Wards of Court Office can provide you with a sample of this statement, and it basically confirms that the proposed decision-making representative is a person who is eligible to act, is willing to act, and is not disqualified by any of the criteria set out in the Act from being a decision-making representative. And this statement covers criteria that's set out in Section 38 and Section 39 of the Assisted Decision-Making Capacity Act. Now I'm going to hand over to Mary Claire, who's going to take you through what's required for the grounding affidavit.
Thanks, Alice. As Alice said, my name is Mary Claire Butler. I'm the Deputy General Solicitor for Minors and Wards of Court. So I'm speaking to you today from the perspective of having done in or around 30 of these applications so far, moved them in court to order stage. So I'm hoping I can offer you a bit of perspective on that. Alice mentioned the notice of motion which you'll have lodged in the Wards of Court office at this stage, and that is only seeking a general relief under Section 55 because, of course, you don't know the specific reliefs until you receive the functional capacity report. So you'll have lodged your notice of motion and you'll have your functional capacity report back. So the next task at hand is the grounding affidavit. And what I would say to you is this: aside from the medical visitor's report, the single most important thing the court is interested to hear about in these applications is the will and preference of the relevant person. So we have to remember that we're moving from a best interest space to an arena where will and preference is absolutely paramount. So as far as you can, or you or your client can, in the grounding affidavit, include the will and preference you know, or you can ascertain, and to take that into account, including the beliefs and values of the relevant person or any other factors that the relevant person might have considered. So try to include the known will and preference covering the areas of decision supporter, which is extremely important, accommodation, that's including present and future accommodation, and any other supportive arrangements that are in place. Also important, and the Act tells us this in Section 8.8, are the views of anybody who's involved in the life of the relevant person, such as a carer, a healthcare professional like a GP or a social worker, or anybody with a genuine and bona fide interest in the welfare of the relevant person. Now, from a practical point of view, it can be difficult to have all of this captured in your grounding affidavit at this stage. It can be canvassed again when you're serving the relevant person because you'll be serving them twice, and you can record further will and preferences in the affidavit of service. I would tell you to start this process early. So engage with the relevant person, have you or your client start those conversations about the new Act, and provide easily accessible information to them about the process. There's a really good leaflet available about leaving wardship on the Wards of Court website, on the Court Service website rather, and I would encourage you to download a copy of that and print it off. It's really, really useful in explaining the process. Give the relevant person the space to think about the future. Talk to their healthcare facility if they're in a residential placement. And as I said, any professionals that are involved or any family members with a genuine interest. In your grounding affidavit, you'll also need to deal with averments around the tier of decision support that's been recommended by the medical visitor. And as Alice mentioned, this can be one of 3 tiers of decision support or no decision support, or it can be a combination of the 3. Where a decision-making assistant is recommended, this is the lowest tier of decision-making support. And I would say to you, ideally identify the person, who the relevant person wishes to have as their decision-making assistant where possible. However, there is no formal requirement in Part 6 of the Act for a discharge contingent on the identification of a decision-making assistant or the registration of a decision-making assistance agreement, which is unlike the position in co-decision maker recommendation. Only recently I had a case where a relevant person was recommended a decision-making assistant for finances. And this was the only area in which the medical visitor felt that she needed support. However, she felt that she didn't need support in this area and she had enough support from her mental health team and those around her. And that was an expression of her will and preference. And she was discharged from wardship with no decision-making assistant identified at that time. So where does a co-decision maker recommend it? You obviously need to propose a co-decision maker, and that will be identified by the relevant person themselves. Any co-decision maker needs to be obviously willing to act, but they also need to understand the role and their obligations under the role. You need to avert the obligations of a co-decision maker as set out in sections 8, 7 and 8. And these are the considerations essentially that any intervener makes in respect of a relevant person. And that's to permit and to encourage and to facilitate them to participate in a decision or to improve their ability to do so in any intervention. You will need to confirm the existence or not of an enduring power of attorney or an advanced healthcare directive. And you will, just to note that post-discharge, there is a new process to register co-decision making agreements. And I understand that's a process that can take a number up to 4 months. But again, Anya might be able to speak to us a bit more about that later on. So where a decision-making representative is recommended, again, where possible, you'll be proposing a DMR. And again, it's really important to refer to the will and preference of the relevant person about this. However, a DMR is the only tier of decision support where the court will ultimately appoint the representative. You need to avert the obligations of the DMR under Section 8, 7 and 8. Again, you need to confirm the existence or not of an enduring power of attorney or an advanced healthcare directive. If they exist, then you're going to have to address Section 38, subsections 3 and 4 of the Act. And that's just to make sure that the terms of the DMROs, that's the decision-making representative order, are not inconsistent with either the Advanced Healthcare Directive or the enduring power of attorney. And you also need to make sure that the functions of the DMR are not inconsistent with those either. Now, where there's nobody suitable or willing or able to act as a decision-making representative, you then should, in your grounding affidavit, request the court to nominate, or to request the court to request of the Decision Support Service to nominate somebody from the panel maintained by the Decision Support Service. So that is available where there is nobody suitable or willing to act. So then moving on to your exhibits. So for all applications, you're going to need your functional capacity assessment, your schedule of assets, and where the applicant has decided that they would like to use their own medical evidence in addition to the functional capacity report of the medical visitor, that's included also. So all of those documents you will have received from the Office of Wards of Court. Where you have a co-decision maker recommendation and where it applies, you will also need a proposal on funds and assets. So where there is more than €250,000 in court, you are required to place a proposal on how the funds are to be dealt with going forward. It would be, what I would say is it's very helpful to contact the Wards of Court office in advance, and they can give you some indication of how the funds are currently invested, which might give you a really helpful starting point on this. You'll need a copy of those enduring powers of attorney and advanced healthcare directives, and any other orders or reports. So that would be like your declaration order or previous orders in Wardship. And again, these will be provided to you by the Office of Wards of Court. In addition to the first three exhibits I've mentioned, in the case of a decision-making representative, again, where applicable, you need the proposal on funds and assets. You'll need a copy of the enduring power of attorney or advanced healthcare directive if they exist. You'll need a copy of any other orders or reports, and you'll need that statement of the DMR that Alice mentioned, and that's pursuant to Section 38 and 39. And this is essentially that the decision-making representative understands their obligations and confirming that they're not a minor or disqualified to act in any way. And again, the Wards of Court office will happily provide you with a sample for that. You're not confined to those exhibits, so if there's any other material, of course, that you feel is relevant, do feel free to include it, but those are the core documents that you have to include in your grounding affidavit. So now, turning to the service of the documents and the grounding affidavit. So it's not specifically referenced in the Practice Direction High Court 120, and that's the practice direction that governs Part 6 applications. A very strong preference has emerged from the court that solicitors effect service of the materials on the relevant person. Now, essentially, you have a choice here under the practice direction. You can serve the documents that are listed on the left-hand side of the slide, or I find it an awful lot easier to draft and swear your grounding affidavit. Those documents are exhibited, and then you're serving the whole lot on the relevant person. So how do you go about it? You explain the application and the implications of it. So this is where the groundwork I mentioned before helps. So it shouldn't be a new concept to the relevant person at this stage. You're going to explain in simple and ordinary terms about how the old system of wardship is going, and it's been replaced by this new decision-making support system. You're going to go through the medical visitor's report very carefully to make sure that they're okay with the recommendation, that they understand the recommendation, and you need to advise them that they, of course, have a right to seek their own report if they disagree with the medical visitor's conclusions. It might seem really obvious, but use a translator or an interpreter if that's required. So maybe a person may be deaf or maybe English may not be their first language. However, if this is a family member who is to act for you as an interpreter or a translator, do consider how independent or not they may be, and would you be better off with the professional. You need to record their response and their reaction to the papers. And what I will tell you, if there is no response or reaction to the service of the papers, record that fact in your grounding affidavit. It is really important that that is recorded one way or another. Will and preference again, you'll hear me talk about this a lot. This is another opportunity for you to cover off will and preference and expressions of will and preference. And I find especially around the topic of a decision supporter here. And again, it seems really obvious, but if you're serving the relevant person and your client has advised you, say as committee, for example, that the relevant person wants them as the DMR, then you should, of course, verify this independently with the relevant person. So you're now moving on to the notice of motion stage. So you've all that served. Sorry, I should mention, sorry, Alice, the relevant person has to be served by personal service. But if you're moving the application other than as committee, you need to serve the committee as well, but you can do that by registered post. So, notice of motion. Once the ward of court has received your grounding affidavit, your exhibits, an affidavit of service of the documents or the grounding affidavit and exhibits, the wards of court office, once they've checked those and everything is in order, you will then be issued with the notice of motion with the return date. So this is your second service, if you like, on the relevant person. So then you serve your notice of motion on the relevant person again with the date and with an explanation of the application. And again, it's really important to record any view or response. And again, it's another opportunity for you to canvass will and preference. The main thing to do when you at this second service is to try and encourage participation. This is a really big day for somebody to be discharged from wardship, and it's a day that they should be supported or participate in where at all possible or appropriate. Reassure them they've no obligation to talk. We're operating in a hybrid court space at the moment, so they can log on and watch from a computer or an iPad, or they're really welcome to come to court. The proceedings are done with the least amount of formality consistent with the administration of justice. The Act tells us we should do that, so that's what they are trying to achieve in the court. Anybody here familiar with the wards of court list will know the sensitivity the judges exercise in dealing with vulnerable persons. So you'll have served the notice of motion now, and you'll be filing another affidavit of service confirming service of the notice of motion. So you have your hearing date at this stage. So now you have to go and prepare your booklet. Practice Direction High Court 20 is really useful because it gives you a step-by-step guide as to the documents you need in your booklet. So they are as follows. The WOC2 form, which is like the WOC1 form, but this is specific to Part 6 applications. And what I will say to you here is just give as much relevant detail as you can, and in particular, answer the questions in relation to grants of probate and litigation. This is information that the court should have. You will be also filing your notice of motion, which is now issued with the date. Your grounding affidavit and exhibits will be in your booklet, along with your affidavits of service. Your functional capacity report. I have a social work report in here. It's not a necessary proof. It's not in the practice direction, but I find it's a useful comfort for the court to be reassured that there's no outstanding welfare issues, and maybe that the relevant person's place of residence is suitable. Not by any means necessary, but just maybe something to think about. You'll also have in your booklet the declaration order. And again, the wards of court office will provide you with that. Where the person is subject to a deprivation of liberty order or a placement order or any other orders in wardship, they should also be contained in the booklet, along with any prior medical reports, which will also be sent out to you by the wards of court office. Now it's back to Alice for the decision-making representative order.
Thanks, Mary Claire. So the decision-making representative order is where the order that the court will make discharging the person from wardship, appointing a decision-making representative, but it will also set out what the decision-making representative can do in terms of what decisions they take responsibility for. The order itself, it acts as the agreement under which the decision-making representative can act. So the court can confer powers on the decision-making representative. And this might relate to, there could possibly be an ongoing issue. So the decision-making representative has been given authority by the court to take this over. This could be anything from court proceedings to dealing with a complaint maybe in relation to a service provider. It can impose duties, and one of the duties that the court does impose upon decision-making representatives is their requirement to report to the decision support service. And this will be reporting not just in terms of any income and assets that are under their care, but also reporting on the decisions that they have taken. It can attach conditions to making a decision, and the court will also, where appropriate, limit the terms of the order in terms of time and scope. So this is evident at the moment where people are being discharged and the court is appointing a decision-making representative or a co-decision maker, but is of the view that there might be some change in the person's capacity in the near future, and they're requiring a review of the order put in place by the circuit court within 12 months, which is the minimum time that can be provided. So when the court is discharging somebody with a decision-making representative appointed, they will set out that this order is to be, an appointment is to be reviewed by the circuit court at any point in time within a period of 12 months to 3 years. Now, the 3 years is only applied where there is no expectation of a change in a person's capacity. More than one DMR can be appointed for a relevant person. And this might be where circumstances where there might be a joint committee at the moment, and both of those committee members want to continue to act. Or it could be that a family member has been appointed as a decision-making representative under some of the headings, but they might not want responsibility for dealing with the person's property and assets. So they look for a professional DMR to be appointed in those circumstances. And this might relate back to the example I gave previously of where people have received very large personal injury awards, maybe arising out of a road traffic accident or medical negligence proceedings in the High Court. There's a large sum of money lodged in court at the moment that is dealt with by and invested by the accountant of the Courts of Justice, and the current committee feels that all of their time is given over dealing with the management and care of the relevant person, and they don't believe that they would have sufficient time to take on dealing with the person's property and assets. The solicitor who brings the discharge application where a decision-making representative is appointed is then responsible for registering the decision-making representative order with the Decision Support Service. And it is only upon proof of registration of the order being presented to this office that the office will arrange for the release of the property and assets of the person to the relevant person. But in reality, it is the decision-making representative who will take over the management and control of this. Now, what we will say, and this will be covered later, there are committees who have committee accounts at the moment, and one of the options open is if that person is going to continue in the role and now become a decision-making representative, they can look to have their committee bank account changed, entitled to reflect that they are now a decision-making representative and they want to continue with that account as the DMR. So when is a DMR appointed? The decision-making representative will be appointed where the person is found to lack capacity, even with the assistance of a co-decision maker. Or it could be that a person is found to lack capacity unless they have the assistance of a co-decision maker, but there is no person available to them who is suitable or willing to act or able to act as a co-decision maker. So in those circumstances, the Wards of Court Office will request the nomination of 2 panel decision-making representatives, and the court will select one of those 2 to act. Now, this is where a decision-making representative has been appointed, where the person has been assessed as requiring a co-decision maker, and the court will require that the decision-making representative appointed acts as much as possible in the role of a co-decision maker in making decisions jointly with the relevant person where that is possible. You may also require a decision-making representative that's from the panel to be appointed where the court has discharged the person and has set out that they will require the assistance of a co-decision maker, but the co-decision maker proposed and the relevant person have not registered a co-decision making agreement with the decision support service. All wards of court are being discharged with liberty to re-enter the application, specifically in those circumstances. So if the co-decision making agreement is not registered, it is possible to seek an extension of time within which to do so. But even if after that period of time elapses, it may be a case that the court will have to appoint somebody as a decision-making representative and will seek the nomination of 2 panel members from the Decision Support Service. Again, as Marie-Claire stated, the decision-making representative is the only form of support appointed by the court. Where a co-decision maker is required or a decision-making assistant, it's the relevant person themselves who will identify who they want to act as their decision supporter. So return of assets. Now, where a co-decision maker is recommended to the court, as I've mentioned, it's on proof of registration that the accountants of the co-decision making agreement that we will arrange for payment out of the funds lodged in court and the return of any property and assets to the relevant person. The relevant person will require a bank account into which to receive those funds. So if they do not have a bank account already, early in the process, you should be looking to assist and ensure that a bank account is open in the relevant person's name. It takes approximately 3 to 4 weeks for the accountant's office to pay funds out of court. But there's also the issue of registering the co-decision making agreement. So the Wards of Court Office, given the time frame that this may take up to 4 months to do, as it is a whole new process that needs to be commenced upon discharge, the Wards of Court Office will arrange to front load payments to a service provider or to a committee if it's felt that funds will be required for maintenance, for provision of care during that interim period. We are also recommending to all committees that they retain the services of the solicitor who brought the discharge application to provide assistance around the registration of the co-decision making agreement. Now, where a decision-making representative is appointed, it is a slightly simpler process for the return of property and assets to the relevant person, as the solicitor will register the decision-making representative order with the Decision Support Service, and then on production of proof of registration to this office, we will arrange for the return of the property and assets to the relevant person, but in reality, this is to the DMR, which is why it's important that the DMR will have an account open into which they can receive this property and assets or the funds from court and ensure that it's kept separately for accounting purposes. Again, it will take approximately 3 to 4 weeks on production of proof of registration for the accountant's office to arrange for the payment out of any funds that are lodged there. And I'll hand back to Mary Claire now for practical considerations.
Thanks, Alice. It's just a few things to bear in mind in the process. And as Alice mentioned, the importance of a bank account. So does the relevant person actually own and operate a bank account? You'd be surprised at the amount of people that are still operating with cash and collecting their social welfare payments in cash. But if they have financial capacity, and remember that's capacity full stop, capacity with the decision-making assistant, or where they will benefit from a co-decision maker, then you do need to start planning for the payment out of monies from court to the relevant person. So the pillar banks have dedicated vulnerable customer units. So get in contact with those early. This is a new process for the banks also. So allow that time where they to set up the various accounts that you need to. Are there appropriate financial safeguards in the placement? And that includes if the relevant person is living at home. But just consider that. You might assume everything is in order, but there's no harm checking it out before you go into court. Where the relevant person is in a residential placement, a simple email just asking them for their financial safeguarding policies should give you enough comfort there. Not in the slide, but I'm going to mention probate and litigation because that is in the WOC2 form. And again, absolutely not an impediment to making a Part 6 application, but maybe consider the practicalities if you're almost at the end of a process there, how that timing would work for your application. The relevant person's current welfare needs. Are they all being met? Is everything okay there? Again, I've mentioned a social work report. That's just something I do in this office as a practice. It's not a necessary proof by any means, but again, it might just give you that general comfort. Supports for service. So the impact of the service of the documents and the functional capacity report. Sometimes this can be overwhelming or upsetting for somebody, particularly trying to digest and percolate a complicated medical visitor report. So consider the needs of the person, discuss with those caring for them as what might be the best way to approach serving the materials on them. The suitability of persons that may wish to become involved. Again, it seems obvious, but somebody that just comes out of the woodwork out of nowhere and puts themselves forward, you'll have to proceed with caution. In the case of a decision-making representative, it'll be ultimately the court that will decide. I had a recent case where a DMR was to be appointed, and the very strong will and preference of the relevant person was expressed to the solicitor serving her that she wished for her son to be her DMR. Now, she had been brought into wardship a number of years previously, and the general solicitor was appointed in lieu of family members because it was felt they hadn't been engaged enough. However, her son showed a lot of bona fides, and the court attached significant weight to the expressed will and preference of the relevant person here, and he was ultimately appointed as her decision-making representative. If the person is subject to deprivation of liberty orders or any orders in wardship, the structure of that may change. So it goes without saying, when they're discharged from wardship, all of those orders will fall away. A very small number of cases, but just to bear in mind if there's interagency involvement, such as the HSE or the CFA. Again, I tell you, engage with those agencies as early as possible to flag your intentions, because they may need to commence parallel care planning alongside. Alice mentioned paying forward fees, and again, that's a really useful consideration, particularly where you anticipate a little bit of a delay between paying out, and certainly in the case of where there's a co-decision-making agreement to be done. Again, where finances permit, do contact the Wards of Court office to arrange that. In the case of co-decision-making agreements, just a consideration that once the orders are made in wardship, those orders are discharge orders are contingent on the registration of that agreement. So there is more work to do once those orders are made. So just bear that in mind at the end of the process. And the last practical consideration I'm going to talk to you about is draft orders. And you'll all be delighted to know I have a full slide dedicated to draft orders. So practice direction High Court 120 tells us that as practitioners, we have to provide a draft order to the court. So after the usual parts of the order, the very first thing that you'll need to deal with is a declaration as to capacity. So this can be one of a number of declarations under the 2015 Act. Section 55 1A is a declaration that the relevant person does not lack capacity. Now, this applies in a case where the person does not lack capacity or where there's a decision-making assistant recommendation in the functional capacity report because the Act is silent on a declaration in that scenario. And remember, you might have a combination of these types of declarations depending on the area and capacity of the person involved. So the other declarations that can be made are under Section 55 1B Roman numeral 1, and that's that the relevant person lacks capacity unless they have the benefit of the assistance of someone as a co-decision maker. Or you can have a declaration under Section 55 subsection 1B Roman numeral 2, and that's where the Act tells us the relevant person lacks capacity even with the assistance of a suitable person, such as a co-decision maker, and that essentially means that they require the support of a decision-making representative. So after that, you'll be applying for a Section 27 order, which is, of course, restrictions on reporting. And then you'll be applying for an order to discharge the person from wardship under Section 55 5B, and you'll be remitting them to the management of their own affairs, and that's with or without the support of a decision supporter. If it's a co-decision maker, then as I said, the discharge is contingent on the registration of a co-decision making agreement and production of proof of that registration to the Register of Wards of Court within a particular time frame. And there's no way around that because that's prescribed in the Act under Section 55.3. So you must undertake this work afterwards. You need to deal with the remuneration and expenses of the DMR in your order where applicable, and that's all contained in Section 42. You'll also need to deal with finances and property and income, and all of that will be to the particular situation of the relevant person. And finally, you'll need to deal with the review of capacity where it's one of the second, two and third tiers of decision-making support. And that's under Section 55A, which was an amendment to the 2015 Act. And that is a direction by the High Court that the relevant person's capacity is reviewed within a particular time frame in the Circuit Court. And as Alice said, that's being engaged with in the High Court at the moment. And we're seeing everything from 3 years where there is absolutely no likelihood of improvement of capacity to reviews taking place as early as 12 months after the High Court order, where there is either a prospect of change in capacity or the age profile of the relevant person is quite young and the High Court feels it would be worth a review in the Circuit Court sooner rather than later. So that's it. That's my part of the presentation. I'll hand you back to Alice now for the remaining.
Okay, and I'm just going to, thanks Mary Claire, I'm just going to touch briefly on minors. Now, the Assisted Decision Making Capacity Act deals with adult wards of court, but as we have approximately 160 minor wards of court, as they turn 17 and a half years, it is a requirement under the Act that the discharge application will commence and be finished by the time they turn 18 and a half years. So minors who, while the Act doesn't make provision for a guardian of a minor to bring the application, the President of the High Court has directed that the word committee be read to include guardian of a minor, allowing guardians to bring the discharge applications for minors. The Wards of Court Office have got a group of minors who are in wardship for reasons other than capacity. These will be discharged from wardship on turning 18 under the normal course of discharge, and the capacity assessments are not required as part of that. We would ask solicitors to get applications in as early as possible to allow us comply with the timeframes to ensure that a person is discharged and their property and assets to return to them as soon after turning their 18th birthday. There are a very small cohort of minor wards of court who are subject to treatment orders and possibly protection of liberty safeguarding orders. This small cohort of minor wards of court have interagency involvement with the HSC and the Child and Family Agency. If a discharge application is being brought in any of those cases, both of those organisations need to be put on notice, and it would be a requirement in terms of those agencies being able to put in place aftercare programs and which are required on them turning 18 anyway, but for leaving wardship, as those orders will fall away, arrangements will have to be put in place to continue treatment where it's required. If you have any questions about that or are not sure, make contact with the office and we'll be able to confirm if that applies. And now just on to the final slide in terms of administration and sittings. These numbers are slightly out of date, but I think we have approximately 93, 94 discharge applications currently have been received. Low 30s in terms of the number of discharge orders that have been made, and I think there was at least one this morning again. We've approximately 2,150 declared wards of court. 208 of those came in 2023, and we have 157 detention reviews currently before the courts. So that's where somebody's treatment and detention has been reviewed under the Assisted Decision Making Capacity Act. And I'll just add that the requirements under the Act are very similar and in line with the reviews that were being carried out by the Wardship Court at the time of commencement. Discharge applications themselves are currently being heard as part of the main wardship list until the numbers increase, and then you will, on receipt of a suitable number of discharge applications, you will start seeing dedicated discharge lists appearing in the legal diary. So I'd like to thank you all for attending, and I am now going to hand over to Anya Flynn, Director of the Decision Support Service. Thank you, Anya.
So look, thanks very much. Thanks for the invitation to join this event. I think it's really timely. And as you've been hearing, and I think will be clear, the Decision Support Service is very much kind of the life beyond this. We in the Decision Support Service aren't directly involved in these applications under Part 6, except perhaps in the event that we're asked to nominate panel member DMRs in the course of the proceedings. But it could be that the former ward or their newly appointed decision supporter has significant engagement with the Decision Support Service after that. So in the hope that those slides are still moving, Alice, and we're now looking at Decision Support Service and the functions of the Director. As you might know, many of you listening, the Decision Support Service is established within the Mental Health Commission, which obviously has its other functions under the Mental Health Act. And functions of the Decision Support Service I have somewhat summarised here are broadly speaking to promote awareness of the Act, to provide information and guidance, to register and to supervise the performance of arrangements under the Act. And I'm going to be focusing on that particularly in the next 15 minutes or so of these slides. And I'll touch also on our functions to investigate complaints and to maintain panels and to publish codes of practice. So we've heard already today about the new 3-tier framework of support which wards might transition to. I'll say little about the decision-making assistance agreement. As you've been hearing, that's quite a light touch arrangement where a DMA is really just offering practical support, helping the person, in this case the former ward, to access information, to understand that information and to explain what they want to do. But the person, the former ward in that situation, is still making their own decisions independently. Whilst that is notified to us in the DSS, we don't have a direct supervisory role in respect of the performance of a decision-making assistance agreement. And I'll come now and turn to the next 2 tiers, the co-decision-making agreement and the decision-making representative order, which you've been hearing quite a bit about already. All have to apply the guiding principles, so too do the courts and the Decision Support Service. So the first tier we look at then is the co-decision making agreement. And again, Alice and Marie-Claire have touched on this quite a bit. So it could be that as an outcome of the review of the ward of court, the court makes its declaration that the ward lacks capacity unless assisted by a suitable person as a co-decision maker. And we have seen a few such orders so far. So a co-decision making agreement is provided for under Part 4 of the Act, and essentially it's an appointment made by an adult called the appointer, in this case the appointer being the exiting ward, who considers that his or her capacity is or may shortly be in question. And thinking again, as you may be, about who would be suitable to be that co-decision maker, as we've been hearing, this is a relative or friend in a pre-existing relationship of trust. So somebody known to the ward, somebody who's going to be able to interact with them to support them by carrying out these functions. And therefore suitability requires that the co-decision maker is able to perform functions under the co-decision making agreement. So the functions of a co-decision maker essentially are to advise the appointer by explaining information, the considerations that relate to the decision, ascertaining the appointer's will and preferences, that key phrase that's really fundamental to this Act and the guiding principles, helping the appointer, remembering the appointer here being the former ward, to take up information, to look at alternatives and outcomes, to make reasonable efforts to ensure that the decision is made and implemented. But then they are making these decisions jointly. So when something is included in a co-decision making agreement, then that's a decision which has to thereafter be made jointly by the appointer and their co-decision maker. So it's important that these arrangements are arrived at advisedly and effectively that people don't get in their own way, including matters in a co-decision making agreement that perhaps are going to be a problem for them to take jointly, because decisions taken otherwise than jointly are null and void. So important to think about that when deciding about whether a co-decision making agreement is something that you're going to be proposing to the court, and that will be the court's decision then whether it's making that declaration or not. Some practical things that a proposed co-decision maker might need to know. They're entitled to expenses but not remuneration. I think Alice has mentioned this principle that they have to acquiesce with the wishes of the appointer, here the ward, not refusing, for example, to co-sign documentation unless it's reasonably foreseeable that serious harm will result. Now, that doesn't give any co-decision maker a right of override, but rather it simply means that for these purposes, the co-decision making agreement isn't going to work. So it might be back to the drawing board, but it doesn't mean that the co-decision maker ever gets to decide for rather than with the person. So even when that serious harm is a foreseeable possibility, it doesn't mean the co-decision maker gets to decide instead. And they can't take decisions other than those that are specified in the co-decision making agreement. And you can only have one co-decision maker per co-decision making agreement. Otherwise, you could have co-decision makers and things become complex. I think we've touched already on the ineligibility criteria that tend to apply across the Act, so that a person would be excluded from stepping into one of these formal supporting roles if they had certain criminal convictions relating to the appointer, the ward, a history of barring orders or safety orders involving the former ward or a child of the former ward. Bankruptcy and insolvency grounds can get in the way if the intention is to be involved in property and affairs decisions. And if the ward is resident in a designated centre or mental health facility, then the owner or a registered provider or an employee of that facility wouldn't be eligible to become, in this case, a co-decision maker. So they may be matters worth considering if it seems that the proposal might be to look at a co-decision making agreement. Now, the application to register a co-decision making agreement comes to us in the Decision Support Service, and the Act sets out quite a detailed process involved in certain prescribed timeframes and requirements for registration, including the signing and witnessing and various supporting documents that are required in order to bring a co-decision making agreement to us. So I know that the time frame of perhaps 5 weeks has been mentioned in order to try and have the co-decision making agreement in place once the Wardship Court makes that declaration, but that is probably too short under the Act, in fact, for reasons that I'll explain, because notice parties have to be given a certain period potentially to raise objections. So the DSS under the Act specifies the form of a co-decision making agreement. And thinking about this category of appointer here, the former ward, we are looking at perhaps trying to streamline, somewhat fast track these applications, because there will already be people able to verify the identity of the former ward and get them set up with the DSS. So it might be possible to move past some of the initial engagement with the DSS, which would arise if somebody was simply out in the world and making a co-decision making agreement. So we are looking at having a single point of contact here in the DSS for these exiting wards who are looking at co-decision making. As I mentioned then, the parties, in this case the ward and their co-decision maker, do have to give notice under the Act to a list of notice parties, including the ward's spouse or partner, if so, and any adult children. The documentation which comes to us together with the co-decision making agreement are statements by the ward confirming that they understand the significance of a co-decision making agreement, and from the co-decision maker undertaking to comply with their obligations under the Act. Character references are required, and so also a capacity statement by a registered medical practitioner or healthcare profession as named in regulations. So these are requirements under the Act, which we have had to incorporate into our processes. So I think you can probably see, if this is the intended course, there is quite a bit of organisation involved. And I think Marie-Claire and Alice have both said already, you know, equip yourselves if you can with this documentation, perhaps before embarking on the Part 6 application, to try and shorten the process, because there is quite a bit of admin effort involved here, and then the notice period of 5 weeks. Because we take in the application for the co-decision making agreement, we have to review it to make sure that procedural criteria have been met, and also to look at any objections which have been raised by notice parties, who are given 5 weeks to raise these objections, and the specified grounds in which they can do so are set out in the Act. We can refuse to register on the basis of a well-founded objection. If we find that there is some procedural aspect lacking, then we can allow the parties an opportunity to correct. But if the requirements aren't met, then we can refuse to register, and that becomes subject to a right of appeal to the Circuit Court. So quite a bit involved in terms of registering a co-decision making agreement with us. So do bear that in mind, and that the necessary turnaround times which would apply. And I know that we've engaged directly both with Alice and Marie-Claire's office on the practicalities of this. So then, following registration of a co-decision making agreement, it's important for a co-decision maker to understand quite what they're getting into. Thereafter, after it's been registered with us, both the co-decision maker and any of those notice parties have to come to us if the appointer's capacity deteriorates or improves. The idea of capacity at the level of co-decision making is that the person, the ward in this case, has the capacity to appoint a co-decision maker, needs them in order to make the decisions covered off in the agreement, and together with the co-decision maker will be able to make these decisions. So quite a nuanced approach to capacity, which has to hold true for the lifetime of a co-decision making agreement. And we keep that under review. Under Section 26, the DSS has to review a registered co-decision making agreement within the first 9 to 15 months, and thereafter every 3 years. Satisfying ourselves that the criteria for registering it in the first place continue to apply. We have to take in updated capacity statements, and if we're not satisfied that it's correctly still in place, we can apply to remove the co-decision making agreement from the register. And importantly, there are reporting conditions. So a co-decision maker entering into this, signing up for this, completing the declarations, needs to be aware that they are going to be supervised by the DSS, and that involves keeping accounts and submitting records to us, submitting annual reports in a template format which has been specified by the director and approved by the minister. And if we can't get compliance with reporting, we'll give the parties an opportunity to correct that. We see ourselves very much as supporting the supporter. But if the co-decision maker falls out of compliance with reporting, then we can determine that they should no longer act, and that would be subject to an appeal which lies to the Circuit Court. So as you can see, a fair bit involved in the registration and ongoing supervision of a co-decision making agreement. Less involved for the DSS to do at the entry point, obviously, of a decision making representation order coming to us, because that's all happened in court. The court, as you've been hearing, has looked at the suitability of DMRs. The court has considered the wishes of the exiting ward and has deemed that the DMR is suitable. So nothing for us to see there. That conversation has already happened. So the DMR is appointed, as you've been hearing, when the court concludes that the ward lacks capacity, even if they have a co-decision maker, and the top tier has to be resorted to. Alice has mentioned this already. It could be that a ward could end up with a DMR in a way by default, because the court has made the earlier declaration that the court thinks that here is a ward who would be fine with a co-decision maker, but for whatever reason a co-decision making agreement doesn't happen. There's nobody available or suitable to do that, or something goes wrong with the process that a co-decision making agreement isn't put in place within the period allowed. If that happens, and the ward therefore ends up with a DMR, likely to be a panel DMR in that default situation, then under section 41.3, which was inserted by the Amendment Act, that DMR has to ensure, insofar as practicable, to make decisions jointly. So that's something that we'd be looking at when the DMR is reporting to us. If that's the circumstances of their appointment, are they doing their best to make decisions jointly with the former ward? And when there isn't a suitable DMR, as you've been hearing already, the court can seek nominations from the DSS panel of DMRs, and that's been happening increasingly so in recent weeks. We've noticed we're getting increasing requests for panel nominations, both from the Wardship Court and from the Circuit Court managing these applications under Part 5. It's possible that some people listening, in fact, are on our panel of DMRs. There are about 90 DMRs across all the Circuit Court areas, and then obviously available also to the Wardship Court. And they're drawn from diverse professional backgrounds, primarily, I would say, law and social work, all interviewed by us, subject to a competency interview, GARDA vetted. They have to maintain their professional registration and carry indemnity insurance, and they are subject to training, which is updated annually. So the DMRO, having been decided on by the Wardship Court, comes to the DSS, as you've been hearing, for entry on our register. And then the DMR has reporting duties rather similar to the co-decision making, the co-decision maker. What I have here is a screenshot of the leaflet which we have developed and have made available in courts, both the Circuit Court and the Wardship Court, I believe as well, setting out the reporting duties of a DMR, because they're not to be embarked on lightly. They are quite significant reporting duties, and certainly in the early stages, at least in the Circuit Court, we found that perhaps DMRs didn't always know exactly what they're getting into and the reporting duties that they were going to have to undertake. So a DMR's authority, as we've been hearing, is always limited to the terms of the order of the court. So it isn't to go forth and decide everything for all purposes. These are intended to be quite precise orders, giving the DMR specific authority, and they can't stray beyond that. The Act does set certain limitations. There are things that a DMR is never authorised to do, so they can't make decisions about life-sustaining treatment. They can't keep another party away from seeing the person, away from seeing the former ward. And there are particular limitations and approvals required around the making of gifts or dealing with trust property as well. So those are matters that we would be looking to when they're reporting to us. And that report is provided for under section 46. So they send in annual reports again in a template, which has been prescribed by us. The court could direct, may have directed in making its DMRO that these reports are submitted sooner or more frequently. And this annual report has to include details, as you've heard, on the performance of the DMR's functions and records of transactions, costs, expenses, and any remuneration which the DMR has claimed. And they might be entitled to that if they're doing this as part of their trade or profession. If they're appointed in relation to property and affairs decisions, as many exiting wards will require, then the DMR is reporting to us after 3 months with a schedule of assets, liabilities, income and expenditure. So again, that's something to be considered. I think they'll be helped in this, I suppose, if this is an exiting ward, because a lot of that information will have been gathered up anyway for the Part 6 application. Again, they're maintaining and submitting accounts and records. They have to make their records available for inspection by the director or by one of our general visitors, and they are a panel of professionals who help with our supervision functions. If we find that there isn't good compliance with reporting, then we can escalate this to the court. So if we're getting late or incomplete reports and performances in some way unsatisfactory, then it may have to come back into the court. We investigate complaints, so we can investigate complaints against any of the different categories of decision supporter under the Act, and looking here in particular at complaints about co-decision makers or decision-making representatives. Again, this is part of the supervision of the safeguarding aspect of what the DSS does. I've somewhat summarised the grounds of complaint here. So a complaint could come to us that here is a co-decision maker, a DMR, who's acting outside scope of function, who is unsuitable. It could be in the case of a co-decision making agreement, the allegation is that there's not compliance with will and preferences. Or that fraud, coercion or undue influence is being used, or that capacity isn't what it needs to be. And then we have pretty standard powers to summons witnesses, take up evidence, apply to court, this being the circuit court for determination, and we could do so on an interim basis if we apprehend that real harm is going to result. We would aim as far as possible to be able to resolve complaints informally. So this would be at the high end of things going wrong, and we hope that we don't see too much of this sort of thing, but it's important obviously that the safeguards are there. Codes of practice were published last year prior to commencement. So any co-decision maker, any DMR embarking on this would be aware that there are codes of practice for those roles, decision maker and the DMR. And a person concerned shall have regard to a code of practice when performing any function in respect of which the code provides guidance. And as this audience might know, there's also a DSS code for legal practitioners. So the codes are up there on the website with other guidance materials, guidance in relation to the codes, illustrative vignettes, and a bundle of other materials, explainer videos. And there are codes, guidance specifically for co-decision makers and guidance for DMRs. So do perhaps have a look at those if you're considering an application which could result in either a DMRO or a co-decision making agreement. And finally then, just to clarify what the DSS does not do, because this is all quite new, but we don't provide legal advice. We don't, as I've been saying, have that direct role in relation to these applications to court. We may become involved at the end if an order comes our way or a co-decision making agreement comes to us for registration following the wardship review, or if we're asked for a panel member nomination during the process. But otherwise, we're not a notice party, and this is obviously managed very capably by the Office of Wards of Court. We don't directly appoint decision supporters. So whilst we have that panel of DMRs, we cannot find a co-decision making agreement, a co-decision maker for somebody or a decision making assistant. We never make decisions for relevant persons. In some other jurisdictions, offices a bit like ours are the decision maker of last resort, but no provision for that under our Act. And we don't have any function to manage the relevant persons, in this case, the ward's money or property. There was provision for that before the Act was amended, but it's very clear that that isn't available even as a fallback position. That doesn't come to the DSS. So that is what we don't do. Much more information, as I say, is available on our website. A bundle of various resources are there, and we do actually take queries around this, and happy to continue to collaborate with Alice's office and Mary Claire's in relation to this particularly important aspect of the Act. I'll stop there. Alice, thank you very much.